In our previous lesson on the English legal system, what we did was introduce the subject of the rule of law. Now, this lesson is just going to continue this in a brief amount of detail by talking about one of the most prominent interpretations of the rule of law, this being the rule of law theory that is pushed forward by and is elucidated by A.V. Dicey. Which I've written here as D.V. Dicey, but yeah, it is A.V. Dicey's interpretation of rule of law, A standing for Albert. Um, we know already, and I've made mention of A.V. Dicey in previous lessons, and we'll talk about Dicey in a lot more detail when we continue looking at the UK Constitution. But we know that A.V. Dicey is one of the most consequential legal minds and constitutionalist this country has ever seen. Specifically within the late 1800s, he contributed a number of different theories, principles, and understandings of the UK Constitution, the various role of the institutions within the UK government, and as well as this principles of constitutional law and our English legal system. Arguably the two most important theories that he developed were his elucidations of the principle of parliamentary sovereignty, which we'll touch on very briefly in this series, but in a lot more detail when we do it in public law, as well as his theory of the rule of law. We're going to talk about his interpretation of the rule of law, and this is arguably one of the most popular views on what the rule of law constitutes, what the rule of law actually outlines and tells us we should do and how one should act. So, A.V. Dicey believed that the rule of law is derived out of three main principles of law. So we noted in the previous lesson that one of the things that the rule of law is difficult to do is to define in a quite succinct and clear way. And so as a result of this, people tend not to try and make and come to a complete definition of the rule of law. Instead, they try to look at the various different principles which the rule of law is said to inhabit. So different principles that, assuming you have these different principles and assuming that we can elucidate these different principles, we can then make the conclusion, therefore, that these constitute the rule of law. And A.V. Dicey is no different. He comes to the conclusion that there are three main principles, which, in conjunction with each other, we say is sufficient to create the rule of law. These principles are the fact that there is a lack of arbitrary power in the state, the law is equal, and then the final of these being that the law is supreme. So these are the three major principles that derive out of the principle of the rule of law. Beginning first then with the first of these principles, which is this idea that there is a lack of arbitrary power. The law does not establish the limits on what people in society can and cannot do, but the law also sets limitations on what the state can and cannot do. So we know from previous lessons when we looked at what the law is, we suggested that the law is essentially an elucidation of rule-making within society. It limits what people can and cannot do within a society. But for A.V. Dicey, one of the principles that is elucidated within the rule of law is this idea that it is not just what society can do and what society cannot do, individual people within society, but it is also a limitation on the power of the state. And so, in doing so, where the state is acting beyond their power, they are said to be acting beyond their authority. The Latin phraseology for this is to be acting ultra vires. And if they are acting ultra vires, then the law can step in and hold them to account. This is what the idea of lack of arbitrary power enshrines, that there is not this arbitrary power that exists within the legal system of England and Wales. Instead, where there is the acting of arbitrary power, where there is the acting of power beyond their authority, where the state does act ultra vires, then the law exists as a safeguard against arbitrary power and therefore holds them to account and checks their authority. Now, this is done in a lot of places through the process of administrative law, and we will get to this when we look at judicial review in the second half of our public law series. But when we talk about judicial review, it is a process by which we can limit the power of the state to be acting ultra vires, to be acting beyond their authority. And so this is where judicial review comes in. There is also other elements of administrative law that exist that can hold the government to account. But this is what the process of judicial review essentially entails. And the understanding here is that the state is limited by the rule of law. And the reason why this is the case is to protect a number of very fundamental and very foundational principles of the state. These include principles pertaining to democracy, as well as principles which protect the people against dictatorship and despotism. The second principle of the rule of law is this idea that the law is equal. There is equality. It means that not only is the law equal in and of itself, but that the law applies in an equal manner. It must apply to everyone equally. And so discrimination within a legal system is a fundamental violation of the rule of law. And as a result of this, it applies the maxim. The equal maxim implies that nobody is above the law itself. So when we talk about the application of law, I made this very clear in the previous lesson, that it applies to whom it needs to apply to, essentially. So, for example, the criminal law applies to everybody. It is universal. But if you, for example, do not own a company or do not operate within a company, then it doesn't make sense to suggest that the UK's company law applies to you. It applies to everybody who owns a company equally. Similarly, if you do not have kids or children, then you're not going to be subjected to child law so long as you don't have kids. If you then have kids, then you will be subjected equally. That's the general rule that is applied. And it means that it does not matter how rich an individual is, how poor they may be, whether they are black or white, male or female, they must be treated equally under the law. Now, one of the things that is quite interesting here is the constitutional position of the monarchy in this regard, because the monarchy, from a constitutional perspective, is actually seen as above the law. They are the makers of law. They are the administrators of law. It is the crown that the subjects essentially. The subjects, i.e., the people, where the law applies to. It applies to the people, and the crown owns the law, if you will. And so there is this question of, well, if the monarch, if King Charles III decides, therefore, to commit a crime, how does this reconcile with the principle of the equality of law and the fact that nobody is above the law? Now, strictly from a constitutional perspective, the monarchy is seen to be above the law. But in terms of practical application, if for example the king was caught speeding, they would probably, as a system, actually apply the law themselves, or at least have the law applied onto them, and accept any kind of legal punishment that is imposed, owing to the sort of way in which the monarchy, by convention, is seen as is viewed as above the law on paper, but in reality is seen as a subject of the law in a similar way, because essentially this begs the question about where sovereignty lies. And that's a quite interesting debate and discussion to be had. In fact, there are quite a few different debates and discussions that are had relating to what the monarch can do in a certain situation, whether that be violating the law or declaring war, or even things like refusing royal assent for bills to become legislation. All of these things really put the Constitution in crisis if they were to ever happen. The final principle that A.V. Dicey elucidates is this idea of supremacy of the law. Essentially what this refers to is the principle of supremacy of law, and I've written here the principle of supremacy when it comes to Parliament, but it doesn't necessarily refer specifically to Parliament, because at the time that A.V. Dicey was writing, the idea of statutory provisions becoming and being a significant source of law was less of a factor than it is today. For example, the statutory provisions within the legal system are far more substantial in today's common understanding of the Constitution than previously. But essentially, A.V. Dicey is elucidating the idea that the law is supreme, and the law has supreme sovereignty and authority. And we then can tie this into the principle of parliamentary sovereignty, in the sense that Parliament today is the supreme lawmaking authority in the United Kingdom. Nothing is above Parliament. Nothing is above Parliament's ability to create new law. And so essentially this means that parliamentary legislation is supreme. Parliament has the ability to make and unmake any law they so choose. We'll get onto this in more detail in a few lessons on the English legal system, and we'll get into it in a great amount of detail in lessons on constitutional and administrative law in future lessons time on that particular topic as well.